Welcome to Work Comp Talk, a podcast dedicated to all the injured workers here in California. I want to thank our lovely sponsors, Pacific Workers, the lawyers for injured workers. My name is Carmen, your host, and this is the Best of Work Comp Talk series where we highlight the best episodes from the podcast into one. And I also wanted to give you a heads up. Season 5 is coming up. It's coming up pretty soon, and I'm excited because I'm going to be able to share so much more knowledge with you as I embark this new season, along with many other co-hosts that are also attorneys for workers' compensation. So we're going to get different views and different concepts, different ideas that are going to come from these other attorneys. And you'll also get to meet other great people that belong to Pacific Workers. So I hope you join us for this. And I also hope you like this best of Work Comp Talk. I'll catch you guys next time.
Today's topic is very interesting. It comes up a lot, believe it or not. And it has to do with settlements, and not the type of settlements that you're thinking of, but what happens when there's a settlement on the table and someone decides, I don't want it.
So what happens when you don't take a settlement? But there's always that one case where someone says, you know what, I don't want to accept what the insurance company is offering me. I want to go to trial, or I want to take my chances, whatever those are.
Right.
And that comes up pretty frequently.
Why would someone want to go to trial and have that jeopardy of, I might lose everything?
There's a few different reasons why your case could be denied, right? Either a doctor says it wasn't work-related, or legally your case is barred. Statute of limitations, for example, you waited too long to file.
It's a he or she said. It's
Right.
you against your company.
That's what trial's really all about. And so, in law, we always joke there's three truths. There's your truth, there's the other side's truth, and then there's whatever convoluted version of that comes out that the judge believes is the actual version of events, right? Some people have the attitude that they would rather get nothing than something because they don't want to cop out. They don't want to give up. Them taking your case to trial isn't nearly as big of a deal as you think it is for them, but it's everything for you. As a lawyer, I have ethical obligations to represent my client's interests. That being said, it's not indentured servitude, meaning I'm not obligated to do things that I morally or ethically object to, or legally object to, things that I don't think I can support, because part of my ethical obligation is vigorously representing my client's interests. If we get to a case and we take it to trial, and maybe it's a 50-50 shot where I'm not confident or I don't feel good about it, but I still think there's a chance, and we take the case to trial and we lose, there is an appeals process.
Right. Ultimately, you don't get the settlement and you lose the trial.
I think there's also the component that people want to go to trial because they want something that they can't have. There are clients who come in who have an abstract number in their mind, and they want that number because they feel as though that's adequate, but it's not necessarily tied to anything in particular, and they don't really understand the difference between, what they may see in commercials or when they hear about their friend's case who got X number of dollars versus what they're being offered, and not understanding how all those things align and what's possible. And I think that causes problems because then they have this expectation that they're going to get far more that even in the best case scenario, they could actually get in workers' comp.
Does this turn out bad? 90% of the time?
They can award penalties and sanctions if there's wrongdoing in a case. Mm-hmm. And if they can't give me more than that, I'll let the judge decide. Well, the judge has no power to award money in lieu of future medical care. We can't force the insurance company to pay more than what they want to pay for to buy out your medical.
Right.
So it's a pretty big difference in value to you.
So what you're saying is, if I think I am worth $100,000 and I got offered $30,000, there's no way in the world that I can just go to trial and hope that the judge is going to give me those 100, because it's not even in his authority to be able to give that type of money.
And in fact, if you have an attorney and they're telling you,
don't go to trial, don't go to trial.
Or they're literally telling you, you can't get that. They tell me, they're like, Bilal, I want to try the case. I want to go to trial. It's up to the judge, whatever the judge says. And I'll tell them point blank, like, the judge can't do that for you. Like, they absolutely can't do that. I think a lot of times there are clients who say, you know what, I guess I should have taken the offer, things like that. There's other clients who are like, you know what, screw it. We tried, we did our best, we still lost, it's okay. You know, I got to be a thorn in their side and be a huge pain in the ass. I made them work for it. And you know what, if that's what the judge decided, that's what the judge decided. And I've made peace with that.
Mm-hmm. And your attorneys tell you not to. I guess, like you said, it's like everything. And it sucks to say this, but every case is different.
The QME is the medical evaluator who really decides a lot of the...
Who puts the numbers.
You know, peace of mind. There's a lot of settlements that come up and there's no negative repercussion for not accepting it. Usually, if there's... The times where it matters most is when there's like a time limitation where the adjuster's saying this offer is only good for X number of days. But there are circumstances where you could end up with nothing. Every person in workers' comp is owed more than they get. I don't care how much they're getting in settlements. I don't care if you get a settlement for $5 million, your case is probably actually worth $10 million. And so just the system doesn't compensate people like it should. And so even if you get everything you should get, you're still not getting enough. And so I think more often than not, people are left with this like insatiable feeling that they got screwed, that they didn't get what they should have got. And that's most cases, just because of the system.
Yeah.
Joining me today is my co-host, Bilal Qasim, and we have lots to discover today about what is not covered in the workers' compensation system. People believe they're entitled to X, Y, and Z within the system, and then comes to show that, no, you're not entitled. Let's talk about the sad part. Unfortunately, there are some, and these are things that are not covered.
I think the first thing, and we've talked about this before, is really what workers' comp is a system, right? It was designed so that you can't sue your employer for things like negligence. You can't assign fault to injuries. And so the trade-off is, because you get your benefits, that your damages are limited. Mm-hmm. And one of the prime examples of that are things like pain and suffering. So normally in a personal injury lawsuit, you can allege things like pain and suffering, which is just the sheer fact that you've been injured and you can't work or do other things, or you've lost quality of life. That's not the case in workers' comp. You can allege things like psychological stress, you know, sexual dysfunction, loss of sleep, but the way the law is written now, unless it's really a catastrophic injury, you can't recover permanent disability for those things. So, you know, pain and suffering at one point was kind of recoverable, because people used to say, you know, applicants' attorneys would file cases and say, okay, well, this person hurt their back, therefore, you know, they can't have sex, sexual dysfunction, they're not sleeping because they're in pain, so sleep disorders, and psychological distress because, quite frankly, they're miserable because they're pain all the time. And those would get evaluated, permanent disability would be assigned, and it would really increase the value of the case. The legislature changed that around 2013 so that you can't really rely on those things anymore unless your injury meets certain criteria. There were several factors the court would consider in determining whether or not an injury is catastrophic. And ultimately, they look at the significance of the need for treatment, the ultimate outcome of that person's medical condition after the treatment's basically plateaued, you know, the value of the permanent disability, and, you know, their need for future medical care, their effect on what they call ADLs, activities of daily living, meaning how significant has the injury impacted their day-to-day. If you happen to have a very specific skill and you're displaced from your employment, what are you supposed to do?
Yeah.
The amount of money that you lose from not being able to pursue the career that you were trained for and you have experience in is not compensated in workers' comp. They don't say, oh, well, you can go find a different field now, but we're going to pay you what you would have earned as an electrician for the next 25 years. I think the next biggest one that comes up frequently, I guess you'd call them punitive damages. Punitive damages in the legal sense mean that you're punishing the person at fault.
Which we see in personal injury.
People think they get jury trials in workers' comp.
I'm going to convince them.
I've heard a lot. I've heard clients say, you know what, I'll let the jury decide. Jury of your peers would be more sympathetic, I think. But
yeah.
In workers' comp, we have administrative law judges, which they preside over the cases. They make the decisions. They preside over the trials. They are the one who's in control. You don't get that in workers' comp. I think a lot of people think that they're going to get into court and it's going to be a full-blown trial and there's going to be a jury and I'm going to give this opening statement and I'm going to make
see on TV,
grand closing argument, and that's not something that happens in workers' compensation. Yeah. People also think the judges have a lot more discretion than they actually do to decide certain issues. You know, I have clients who come and say, well, I'll just let the judge decide.
By the way, we have an entire other episode that talks about what you expect in trials, and we did talk about what are some of the things that judges can and cannot do, and again, these expectations that are built from the injured worker's mindset of the judge is going to hear my story out.
And the judges have very limited powers that are established in the labor code and, California Code of Civil Procedure and stuff. And that's basically it. So,
Damn.
I think there's that bit of mistaken information out there that people think the judge can do a lot more. I'm sure there's a ton, but I guess one is, job retraining, and now it's much more limited than it was before. We used to use this term called vocational rehabilitation, and it was a benefit that was much more robust. I'll say this, back in the day. Now it's a voucher for up to $6,000 in job retraining, plus you get a $5,000 stipend from the state if you're entitled to the voucher in the first place. But that's it. If you need to go back to school and it costs you $50,000,
that's on you.
Too bad, so sad.
But if you look at it in the positive, and you have to always find the positive when you're in situations like this, it's $11,000 or nothing. When there's a way, there's a will. So
yeah, but workers' comp really tests your patience.
Oh.
There was this law firm, they had this press release that they put out, and there was this guy, I guess he was injured, and they settled his case for, which at first glance in workers' comp is that's like $100 million in any other context, right? It's a big deal.
Yeah.
And then you read the details of the case, and it turns out the guy was injured back in 1989 or something crazy. He would have been far better off had he actually just gone to work and earned a paycheck rather than getting this settlement. So, basically gave up whatever 30 years of his life for this, amount of money that all things considered isn't much, for what he went through. So, I think that says a lot about what workers' comp can really deliver and achieve for people.
It's kind of it's a system that a lot of people don't know. It might seem like it's a cookie cutter. I'll Google it. I'll figure it out. But it's very different. It's not like when you're going to the doctors in a normal case scenario, where you need an MRI and you go to your doctor and then they refer you to the MRI. This is completely different. It has a lot of legal intricacies that go into it and a lot of denials and stuff like that. And that's why, one of the biggest important things that we always mention is get yourself an attorney. Despite what some might say, oh, but the attorney's going to get money and I'm not trying to. It's you're going to have peace of mind knowing that you have someone that knows the system, making sure that you're getting taken care of in every way possible and that you're not leaving any money on the table. They have a legal team, the insurance company, all the time, right? They have an attorney.
Yeah, a lot of insurance companies have attorneys in-house that work for the insurance company. They also associate with outside counsel, even if there's no attorney of record, they could still be consulting with an attorney. So, they have their team too.
It is proven that anyone who hires an attorney gets an additional 30% on a settlement in anything that they're doing just by hiring an attorney.